This presentation relates to our consultation paper, Getting Married, a consultation paper on weddings law. It's a paper that we published in September of this year. I'm Nick Hopkins, the Commissioner for Family Law, and I'm joined on this presentation by Professor Rebecca Probert, our expert consultant on the project, Elizabeth Welsh, the Law Commission's lawyer working on the project, and our research assistant, Sam Hosseini. This presentation is aimed particularly at religious groups and at couples who have had or would like to have as their wedding a religious ceremony. And so we highlight areas of our provisional proposals on which we're consulting that we think would be of particular interest to those groups and to those couples. They include who is responsible for officiating or attending a wedding, any requirements as to what that wedding ceremony must include, including religious ceremonies, where wedding can take place, and the rules relating to the validity of weddings and to offences related to wedding ceremonies. If you've not come across the Law Commission before, we are an organisation that was set up by Parliament over 50 years ago, and the role Parliament gave us is to keep under review all of the law of England and Wales and to make recommendations to government for reform. We are an independent body. We are an arm's length body of the Ministry of Justice. If you want to see more about how we work with the government, we have a protocol which you can access on our website. For each project that we undertake, we agree terms of reference for the project with the government, and we then work independently from government within the scope of those terms of reference. And so turning now to our project on weddings law. As I said, for all of our projects, we agree terms of reference. And for this project, we've been asked to provide government with recommendations to reform weddings law in a way that will give couples greater choice within a simple, fair and consistent legal structure. Our review is governed by 5 principles. We want the law to be certain and simple and to provide fairness and equality. We want to protect the state's legitimate involvement in weddings. So, for example, the state's interest in knowing whether a couple are married and whether they are legally married, and the state's legitimate interest in protecting against forced and sham marriages. We also want couples to have choice within the legal framework, and we want to reduce any unnecessary regulation that exists within the law. So our terms of reference cover all of the legal issues that relate to getting married. We look at the whole process, starting with the preliminaries, or as they're sometimes called, the notice you give when you want to get married. We look at where a wedding should be able to take place. So we have provisional proposals that would enable weddings to take place in a much greater variety of venues than is possible under the current law, including, for example, outside and on cruise ships. But it would still be possible for religious groups to impose their own requirements as to where weddings that take the form of their religious ceremonies would take place. We also look at who should be able to solemnise a civil or religious wedding and how the law could allow for weddings by non-religious belief organisations such as humanists and by independent celebrants. But the prior question whether non-religious belief organisations or independent celebrants should be able to solemnise weddings is not part of our review. We also look at whether there should be any particular requirements of wedding ceremonies. So, for example, whether specific vows should be required. We look at how marriages should be registered, and we look at the consequences of a failure to comply with any of the legal requirements. There are a couple of policy assumptions that underpin our work that may be of particular interest to religious groups and to couples who are considering a religious wedding. The first of these is that, as is the case at the moment, religious groups should be able to marry people as long as particular requirements are met. And the second is that the definition of religion should remain as it was decided by the Supreme Court in 2013. And so our review is not looking at defining what a religious group is for the purposes of weddings. There are also some exclusions from our project. So these are things that our project will not be considering. They are, first of all, eligibility to marry. So, for example, the age at which people are able to get married. We're also not looking at the ability of religious groups to not solemnise same-sex weddings. That is enshrined in the law at the moment, and that will continue to be the case under the scheme that we put forward. Similarly, we are not considering the duty of the Church of England and the Church in Wales to marry parishioners. That duty would be unaffected by our proposed reforms. We are also not looking at the rights and responsibilities of marriage, and we're not looking at divorce. Our concern is with the legal requirements relating to how couples get married. We're not looking at foreign weddings. We're not looking at how weddings that take place overseas are recognised under the law of England and Wales. And finally, we're not looking at ancillary wedding services, for example, contracts relating to catering that people may enter into when they are celebrating their wedding. So we're consulting on a provisionally proposed scheme. We consider that the scheme we have put forward will replace the outdated, overly restrictive law of weddings, much of which dates from 1836, and which imposes limitations on how and where couples can get married, which may now have historical reasons rather than current social policy reasons lying behind them. We consider our scheme will make the law simple, fair and certain for all of those involved. A key feature of our proposed scheme is that it bases regulation on the officiant of the wedding, so a party who has certain legal responsibilities relating to that wedding, rather than basing regulation around the building or the location of the wedding, which is the foundation of the current law. And finally, our scheme will apply the same rules to all types of weddings with just some few exceptions. So this flowchart illustrates the effect of our scheme from the point of view of a couple who are getting married. Depending on the size of screen you are looking at this presentation on, this flowchart may be very clear or it may not be legible at all, but it is contained in the summary that we have published of our provisional proposals, and so please have a look at our website to see the full version of the flowchart. But it shows that the whole process that couples would need to take under our scheme, from the time that they give notice of their intended wedding right through to the registration of their marriage. So I'm now going to hand over to Elizabeth, Sam and Rebecca, who are going to take you through some key features of our proposed scheme.
Thanks very much, Nick. So first, we're going to talk about who is responsible at the ceremony in relation to each wedding, which is often thought of in terms of who is responsible for conducting the wedding or solemnizing the wedding. So under the current law, only religious groups and registration officers can conduct legal weddings. The rules about who is responsible at each ceremony differ, and they are complicated and unclear. So under the Marriage Act 1949, there are essentially 5 categories of weddings. There are Anglican weddings, which are conducted by the Church of England and the Church in Wales. There are weddings by Jewish groups. There are weddings by the Society of Friends. There are weddings by all other religious groups. And then finally, there are civil weddings, which are divided into weddings in register offices and weddings on approved premises. There are different rules for these different categories of wedding about who is responsible in relation to them. So for Jewish and Quaker weddings, there are rules about who is responsible for registering the wedding and how the wedding must be registered. But there's not actually any requirement for anyone in particular to attend those ceremonies. Conversely, for all other religious weddings, religious leaders or another person who's authorized to register the marriage must attend and register the wedding, and that can be a registrar. And for civil weddings, 2 registration authorities, a superintendent registrar, and a registrar must attend. So in virtually all cases, the person responsible for registering the wedding also has to attend it, but they are generally not required to conduct the ceremony. However, that is not universally true. Under the law, Anglican clergy are also required to solemnize the marriage. These different roles, because they vary, result in a lack of clarity in the law. Now, in addition to these different roles, there are also different rules about how the person who is approved to register the marriage and attend it is authorized to do so. So for an Anglican wedding, it must be a clerk in holy orders who registers the marriage and attends the wedding. Those responsible for registering Quaker and Jewish weddings must be recognized by the organizations that are specifically named in the legislation. So this is a top-down approach for these organizations who can choose not to certify a person, which would prevent them from conducting a Jewish or Quaker wedding under those provisions of the Act. For all other religious weddings, the group must have a registered place of worship. After a place of worship has been registered for marriage for 1 year, then that place can appoint an authorized person, and that person would then be responsible for registering marriages in the building. During the first year, or otherwise if the authorized person is absent, then a registrar must attend the wedding conducted at that place of worship in order to register them. Now, in addition to being complex and confusing, the current law also suffers from unnecessary regulation, and in particular is the requirement for a registrar and a superintendent registrar to attend all civil weddings. This increases costs for local authorities and for couples having these weddings, and limits the availability of civil weddings at popular times such as during the summer. So under our proposed scheme, we propose a system that would rationalize these requirements. Under our scheme, there would be a new role of an officiant, and all officiants would have the same legal duties and responsibilities, which I'll talk about in a moment, and all weddings would have to be attended by 1 officiant. As Nick explained, the focus of the regulation of our proposed scheme would be on this person and their responsibilities. So under our proposed scheme, there would be up to 5 categories of officiant. Now that would depend on decisions made by government on the point of whether or not the groups that can conduct weddings should be expanded, a point on which we are not making recommendations. So under our provisional proposals, there would be a category of registration officers. They would conduct civil weddings, and they would no longer conduct religious weddings under our proposals, and only 1 would be required to attend a civil wedding. There would also be a category of Anglican clergy who would conduct Anglican weddings. Nominated officiants would be another category, and these would be individuals or office holders who were nominated by religious organizations other than the Anglican churches to conduct religious weddings. Also, if government enabled non-religious belief organizations to conduct weddings, then those organizations would also be able to nominate officiants to conduct their weddings. Next, there would be the category of maritime officiants. Now, they would conduct civil weddings in international waters on board certain types of vessel, namely cruise ships. And the final category could be independent officiants. This category would only exist if government decided to enable independent celebrants to conduct legally binding weddings, in which case they could be authorized to conduct civil weddings. So now focusing on nominated officiants. Individuals would be nominated to act as officiants by their nominating body. We also ask in the consultation paper whether nominating bodies would be able to nominate officiants by office, meaning that all holders of a particular office in an organization could be authorized. As I noted, they would have to be nominated by nominating bodies, and that would be either a religious organization or, if enabled to conduct legally binding weddings, in a non-religious belief organization. To be a nominating body, religious groups would have to meet the definition of religion that was given by the Supreme Court in Hodkin. So, a spiritual or non-secular belief system held by a group of adherents which claims to explain mankind's place in the universe and relationship with the infinite and to teach its adherents how they are to live their lives in conformity with the spiritual understanding associated with that belief system. Additionally, they would be required to have at least 20 members who meet regularly for worship or in furtherance of their beliefs under our proposals. And finally, we provisionally propose that such groups would also have to have a wedding service or a sincerely held belief about marriage in order to nominate officiants. In the consultation paper, we also consider and ask consultees whether there should be an express exclusion in the law which would prevent organizations from nominating officiants if that organization promoted purposes that were unlawful or contrary to public policy or morality. So I've spoken about these requirements from the point of view of religious organizations, but if non-religious belief organizations were also able to solemnize weddings, then they would have to meet these criteria, which would be slightly modified to suit them. Now, in order to be nominated by a religious organization to be an officiant, a person would have to be a fit and proper person. That would include a requirement that they had training or continuing professional development, which would be determined by the body that nominated them. Once authorized, religious officiants would be prohibited from making a business of officiating at weddings by elevating the making of profits above the expression of their beliefs. In the consultation paper, we propose a process for authorizing officiants. We note that the nomination will be made by the body to the General Register Office, who would then authorize the officiant, and the General Register Office would be required to maintain a public list of all nominated officiants. We also propose a system for monitoring and for deauthorizing officiants. As I noted, authorization would be for an independent period or an indefinite period, and primary responsibility for monitoring the person would be with the person, the organization that had nominated them. Now just going through the other requirements that would apply to the different categories. So registration officers will continue to be appointed by local authorities as they are now. It would be up to local authorities to determine the requirements they would have to meet. The next category would be Anglican clergy. Now we provisionally propose that they would be authorized to act as an officiant by virtue of being in holy orders. And this is in recognition of the special status of the Church of England and the Church in Wales and their duty to marry parishioners. Independent celebrants, if they were enabled by government to conduct weddings, would apply directly to the General Register Office for authorization. If authorized, they would also appear on the public list of officiants. They would also be required to be a fit and proper person, but for independent officiants, this standard would expressly require that they be at least 18 years old, understand the legal requirements of being an officiant, and had undertaken the prescribed training, which would either be provided by the General Register Office or approved by the Registrar General. Independent officiants would be able to charge fees if they wished. However, they would be prohibited from acting in a conflict of interest. Now, that rule would mean that independent officiants would not be able to require couples to purchase other services from them or to receive a commission for referring a couple to another provider of a service, for example, referring someone to a floristry business. And maritime officiants, as I noted, would conduct weddings on board certain ships. They would be required to be deck officers of those ships, which is a particular sort of senior officer on the ship. And they also would apply directly to the General Register Office for authorization and would be subject to the same criteria that would apply to independent celebrants. So I noted earlier that under a proposed scheme, there would be a common role that all officiants would have to fulfill. And so we provisionally propose that in relation to all weddings in which officiants were responsible, they would have a duty to, at the ceremony, ensure that the parties freely express consent to marry each other, that all other requirements of the ceremony were met, such as the requirement to have 2 witnesses, and that the schedule was signed. All officiants would also be responsible for upholding the dignity and solemnity of marriage. In devising these duties and responsibilities, we have considered all types of wedding, including the variety of religious ceremonies. We think this common set of responsibilities will work well for all weddings, but we invite consultees to let us know what they think. And I'll now pass it over to Sam to talk about the content of the ceremony itself.
Thanks very much, Elizabeth. Thinking about the current law governing the content of ceremonies, there are a number of concerns that we discuss in our consultation paper. One of these is that this is another area where there are different rules depending on the category of the wedding. For example, civil ceremonies and religious ceremonies other than Anglican, Jewish and Quaker ones must include exact prescribed words. They're the declarations that the parties make that they're free to marry and the words of contract. On the other hand, Anglican, Quaker and Jewish ceremonies do not have to include the prescribed words. Instead, the legislation requires that they are performed according to the rites of those groups. There's also a restriction preventing religious content in civil ceremonies. Only incidental religious content is permitted. This rule doesn't reflect the beliefs of many couples who might wish to include content that has religious or cultural meaning to them in their civil ceremony. Finally, there's the requirement for open doors. This requirement applies to weddings, civil weddings, and weddings in registered places of worship, that is, religious weddings other than Anglican, Jewish and Quaker weddings. So another area where there's different rules for different groups. And the requirement doesn't appear to be serving a purpose. In our discussions so far, we've not heard of any occasions where an objection has been made during a ceremony on the basis of the open doors requirement. So thinking now about our proposals for reform. Under our proposed scheme, the same rules will apply to all groups and all weddings. Our scheme doesn't regulate the content of the ceremony any more than is necessary, thereby giving couples freedom to choose the content of their ceremony. The core requirement under our proposed scheme is for each of the couple to express their consent to marry each other in the presence of each other, the officiant, and 2 witnesses. But there will be no requirement for consent to be expressed in a particular way, and indeed consent could be expressed non-orally by conduct. We think that this will accommodate the many different ways in which couples express their consent to be married during religious ceremonies. Now, of course, religious groups, and if they're unable to conduct weddings, non-religious belief groups, could continue to impose their own requirements about the ceremonies that they conduct, including whose weddings they will conduct and the content of those ceremonies. And religious weddings could still be required to take place according to the rites of those groups. Another provisional proposal that we make is that religious content will be permitted during civil ceremonies, provided that the ceremony was identifiable as a civil ceremony rather than a religious service. We ask consultees whether the legislation should expressly state that certain types of content are permitted in civil ceremonies, for example, hymns, readings, imagery, and songs. Finally, we propose there will be no requirement for open doors. Now turning to the law governing where weddings can take place, and thinking again about the current law and some of the problems with it. The current law is often described as a building space system because it requires that most weddings take place in a building that is either a place of worship that's been registered for weddings, a register office, or premises that have been approved for civil weddings. But again, there's uneven rules for different groups. Jewish and Quaker weddings can take place anywhere. And there are also distinct rules for Anglican weddings. Most Anglican weddings have to take place in a public church or chapel, but Anglican weddings authorised by Archbishop's special licence can, as a matter of law, take place anywhere, although we understand, as a matter of practice, they mostly take place in Anglican places of worship. So these rules limit couples' choice. They mean, for example, that most couples can't choose to get married outdoors, in a private home, or on a boat at sea. We also think there are particular problems for some religious couples. For example, for some religious groups, particularly smaller groups or interfaith ministries, might not have their own buildings in which to conduct weddings. And for other religious groups, the place of worship might not be seen as the most meaningful place to conduct the marriage ceremony. For example, we understand that this is particularly the case for some Muslim groups. For others still, there are groups that worship outdoors, and so they don't have buildings for that reason. In practice, we understand that some religious weddings take place in approved premises that are used for civil weddings, and sometimes they take place after a civil ceremony conducted by a registrar. We understand that there's a desire among some religious groups for weddings that take place at home, in private homes. And we've heard that some religious weddings, and in particular weddings by interfaith ministers and by pagan groups, take place outdoors. Turning now to weddings, civil weddings, there are particular problems around the rules that govern locations for civil weddings. Civil weddings other than those taking place in register offices take place on premises that have been approved, and they're approved by local authorities. There's an application fee for approval, and our initial research suggests that the median application fee across England and Wales is £1,500. Now, we expect that this cost will prevent some small businesses that might host only a few weddings per year from gaining approval because it's simply not economically viable for them. So our proposals for reform. Well, our proposed scheme focuses on regulation of the officiant rather than location, and that means that there can be greater freedom about where weddings could take place. Under our provisional proposals, weddings could legally take place anywhere, including outdoors, in private venues such as homes and military sites, and on inland, coastal and territorial waters. There will be no requirement for venues to be pre-approved, and we think that this would reduce unnecessary bureaucracy. We asked consultees whether civil weddings should be prevented by the law from taking place in religious venues. So instead of pre-approval, it will be for the officiant to agree to a given wedding taking place in a particular location. The officiant will be responsible to consider the safety and the dignity of that location. They will be guided by guidance provided by the General Register Office. We think this would increase choice for couples, allowing them to get married in the place that's most meaningful for them. In turn, increased choice should open up lower cost venues, like getting married at home or in small community venues. And it would also drive competition amongst commercial venue providers. Now, our provisional proposals would mean that religious groups, and if they were unable to conduct weddings, non-religious belief groups, will continue to be entitled to insist on their own requirements about where a wedding could take place. Equally, though, religious groups could choose to conduct weddings in a wide range of venues. For example, in commercial venues like hotels or stately homes, or the gardens of those venues, in restaurants, in private homes and gardens, small community venues like village halls or village greens, and in the countryside or on beaches. It will be up to each group to choose what was appropriate according to their religious beliefs. We also consider in the consultation paper whether there should be an optional scheme for pre-approval of venues. Under such a scheme, some venues would already have been determined to be safe and dignified, removing the need for an officiant to make their own assessment in every case. The scheme might be most useful for registration officers. Such a scheme wouldn't require religious groups to conduct weddings in locations that have been pre-approved, but for other groups, again, it will be for religious groups to impose their own further criteria about where weddings could take place. So that's me, and I'm going to hand over now to Rebecca.
Thank you, Sam. So this graphic shows the rules that would apply to all weddings based on the different type of officiant who'd be required to attend. And it shows that with few exceptions, the same rules would apply to all. And like our other graphics, it's available for a closer look in the consultation paper and summary. Now, in requiring certain formalities for a wedding, the law must also consider what the consequences are if a couple fails to comply with those formalities. So we turn now to look at the law governing validity and at the offences that may be committed. The general policy of the law in England and Wales has been to uphold marriages whenever possible. Nevertheless, not all weddings will result in a valid marriage. A marriage may be void or voidable, or the ceremony may not qualify as a ceremony of marriage at all. The current law on the consequences of a failure to comply with the formality requirements, however, are far from clear. First, there's a lack of certainty about the minimum required for a valid marriage. Only certain failures will result in a marriage that is void, and these are all spelled out in the legislation. However, the Act is silent on the consequences of other failures, for example, not having witnesses. The implication is that these failures have no consequences in terms of the validity of the marriage, so a marriage will be valid even if it's not attended by 2 witnesses. Second, the validity rules are different for different types of wedding. For example, any marriage that's preceded by a superintendent registrar's certificate may be void if it's celebrated in a place other than that specified. By contrast, an Anglican marriage is not invalidated by being celebrated in a church in which the banns were not published. Third, the rules are also uncertain. The provisions on validity do not address what happens when a couple has not complied with any of the requirements. Over the years, the courts have developed the concept of a non-qualifying ceremony, what was previously called a non-marriage. The courts have said that there is a bare minimum required to bring a wedding within the Marriage Act and mean that it has legal consequences. But the law does not specify what those minimum requirements are. As a consequence, some couples have weddings that they believe are legally recognised, but which in fact have been categorised as non-qualifying ceremonies. These are creating hardship, because unlike parties to a void marriage, parties to a non-qualifying ceremony cannot apply to the court for financial provision. We understand that this issue is more common among couples who marry according to certain religious traditions, including Islam. Fourth, turning to criminal offences, the offences that may be committed and their penalties also vary, again depending on the type of wedding. Turning to our provisional proposals, these aim to make it clear when a marriage will be valid or void, and to reduce the number of weddings that will be non-qualifying, in particular when the couple believed that their wedding would be recognised under the law. In terms of clarification, we propose that the law should state exhaustively the factors that will or will not render a marriage void. We propose that each of these factors taken individually would make a marriage void. First, the failure of either party to give notice of the intended marriage to the registration service, or, if Anglican preliminaries are retained, the relevant church authority. Second, the wedding taking place after authority to marry had lapsed. Third, the knowledge of both parties that the ceremony was not officiated by an authorised officiant. And fourth, in the case of same-sex marriages, the knowledge of both parties that the necessary opt-in to same-sex marriage had not been given by the relevant religious governing authority. We also propose that the legislation should clarify that certain factors would not make a marriage void, and so would not affect its validity. Such factors would include mistakes in the issuance of the schedule, or if Anglican preliminaries are retained, the marriage document, the absence of witnesses, and a failure either to sign the schedule or, again, if Anglican preliminaries are retained, marriage document, or to register the marriage. In terms of legal protection, our scheme aims to give more legal protection to couples, particularly those who thought that their ceremony would result in a valid marriage. First, it will be easier for a wedding ceremony to fall within the scheme, given that it removes the restrictions about where a wedding must take place, making it easier for a couple's ceremony to result in a valid marriage. It will also make more ceremonies void rather than non-qualifying. If the couple did not give notice, their ceremony could not result in a valid marriage. But so long as they either gave notice or at least one of them believed their ceremony was being officiated by an authorised officiant, their marriage would at least be void. This means that a couple could award financial remedies on the breakdown of their relationship. So here we have a flowchart showing the consequences under our scheme in terms of the validity of the marriage for the couple, should they fail to comply with the required formalities. And it shows that some ceremonies would continue to be non-qualifying, meaning that financial remedies could not be awarded on the breakdown of their relationship. Ceremonies would, for example, be non-qualifying if either party simply did not consent to be married. As is the case now, consent that was expressed but which was vitiated by fraud or duress would be voidable. Ceremonies would also be non-qualifying where the couple did not give notice and neither of the couple believed that they had an authorised officiant at the ceremony. This means that where at least one member of the couple believed that the person conducting their ceremony was authorised, it would not be a non-qualifying ceremony. Instead, it would create a void marriage. Now we know that hardship does arise in the ceremonies that are categorised as non-qualifying. In particular, where weddings take place according to religious rites, they may not comply with any of the legal requirements for getting married. However, we don't think that the ceremonies which would remain as non-qualifying under our scheme, when notice had not been given and when neither member of the couple believed the officiant was authorised, so neither had a reason to believe that their ceremony would be valid, can be solved by the law governing weddings. So it cannot be solved by our project. That's not to say that we think that in these cases the couple should not have a remedy, but it does mean that we don't think that weddings law is the right way to give them a remedy. First, we do not see how couples who have had a religious ceremony, but who did not intend to have a legally valid marriage, or had no reason to believe that it would be a legally valid marriage, can be treated differently at the end of their relationship from couples who've had a non-religious ceremony that did not comply with the requirements, such as a humanist ceremony or one conducted by an independent officiant, or have had no ceremony at all but still suffer hardship when a long relationship ends. In all of those cases, if the parties have no reason to believe that their ceremony formed a legal wedding, the unfairness results from the relationship, not from the ceremony. We also think that it would be very difficult to give legal consequences to a ceremony that complied with none of the formalities for a legally recognised wedding, and which both parties knew was not legally recognised. Doing so would seem to act as a disincentive to complying with wedding formalities, and undermine the purpose of having them, which are in part to protect the state's legitimate interest in weddings law, such as legal certainty, and to prevent marriages where there are impediments to it going ahead. If the couple knew the wedding was not going to be legally valid, it could also be contrary to the intentions of the couple. Again, this is not because we think that people, often women in this situation, should not have a remedy. But we consider that the correct approach is to focus on the consequences of the relationship coming to an end and the hardship arising from the relationship. Reform of the law relating to cohabitation could provide protection for all of these couples. Couples in unrecognised religious weddings, couples who have had another form of commitment ceremony, and cohabiting couples. And the law reform did recommend reform to cohabitation law in 2007. We also proposed to simplify and rationalise offences, removing redundant provisions. Some offences would be reclassified as administrative matters, to be dealt with potentially by withdrawal of an officiant's authorisation, for example, if they had failed to ensure that the schedule had been signed. However, it would be an offence under our scheme to mislead a couple about their ceremony. Specifically, it would be an offence if any person purported to be an officiant and deliberately or recklessly misled either of the couple about their status or the effect of the ceremony, or for an officiant deliberately or recklessly to mislead either of the couple about the effect of the ceremony. So what's next? Our public consultation will run until 3rd of December 2020. We'll then conduct an analysis of the responses to our consultation and formulate our policy, and our final report with recommendations for reform will be published in 2021. So we encourage you to respond to our consultation and all the details about how to do so are available on our website.